Hi, everyone. I'm Lisa Everett. I'm a staff attorney at Houston Volunteer Lawyers. I've been here 8.5 years, almost 9. And today is the final CLE in our June series on probate matters. The first week we talked about probating a will, and probating a will is a munitive of title. The second week was on applications for letters of administration and determination of heirship. Last week was the small estate affidavit and affidavit of heirship. And this is on ancillary matters. It's about other things that we can help people with after their probate is over, or what are the services we can provide to our clients. I will be taking questions during the CLE. You can post them in the chat, or you can post them in the question and answer. My coworker Kiara is going to be monitoring that, and she will interrupt me if I don't see it. And I will also take questions at the end. The CLE information is in the chat, and it's also right here. And I'm going to go ahead and get started. So today I'm going to encourage, I already introduced myself, I'm going to encourage everyone to take a case, whether it's probate or something else. Also, we're going to be going over, like, you've done a probate case, is more work needed, like to actually help probate the estate. Normally that's an affidavit of heirship. We'll talk about that a little bit. We also want to talk about maybe informing and educating our new homeowners. Some people are going to be inheriting a home. It's going to be their first time owning a home. And because they're not going about it, getting a loan and all that good stuff, they may not be aware of their duties for various reasons. We also might want to let people know about non-legal assistance that they can apply for. Some people will want to use something like an affidavit of heirship, or they might be interested in unclaimed property that's been turned over from some company to the Secretary of State. We'll talk about the affidavit of heirship for motor vehicles, IRS taxes, and I'm still going to encourage y'all to take a case because we are Houston Volunteer Lawyers. Y'all are our volunteers, and I want everyone to please help people by taking a case. So I already said that I'm Lisa. I do a lot of landlord tenant and evictions. If anyone has any eviction, or if you have any interest in taking an eviction case, I would also be the mentor for your eviction case. And so I will always plug the evictions. We still are in a crisis, and there's a lot of assistance available to people. And they are more likely to get the assistance and the relief in court when they are represented by an attorney. So I am just going to make that quick plug for evictions. I also do consumer, probate, title clearing, and because I'm a Houston Volunteer Lawyers, a little bit of everything else that is civil. The reason why we do probate is for property preservation. For most people, the most valuable asset they own is their home. And if their descendants lose it because they don't have clear title, or through intestacy, that can lead to income inequality for the people who lose it. And it's also a way of building generational wealth. And so we're helping, Houston Volunteer Lawyers, you have to qualify in order to receive our services. So we're talking about people that are generally at 200% or less of the poverty level for most of our cases. And these are people who can't hire an attorney. And we are hoping that maybe we can help build some generational wealth, keep them in a home, or maybe even help them get some cash if it's from a bank account or something like that. And those are assets that these people really need. Sometimes people come to us, they didn't realize they didn't have title to a home, but they've applied to like the city or some private nonprofit for assistance to rebuild or repair a home. We see this is especially a big deal after natural disasters like Hurricane Harvey or FEMA. If they're applying for assistance for a home, they have to prove that they have clear title, and a lot of people can't. And so that's why we also call it title clearing. And we also do it sometimes when someone's coming to us because their home's being foreclosed on by the property tax or by the taxing authorities. And if someone is over 65 or disabled, as many of our clients are, we can help them stay in that home and keep them from being homeless by helping them clear their title. Just so you know, some of the abbreviations you might see today are SEA, that stands for Small Estate Affidavit, AOH, Affidavit of Heirship, and HCAD, that's for the Harris County Appraisal District. So you are getting some ethics today, and this is why you're getting it. We're going to talk a little bit about working with legal aid clients. In general, we want to approach them with empathy and without judgment. Sometimes And by that, sometimes we may not understand the decisions people have made or how long they've decided to put things off. A lot of our clients have, this may not be the only issue in their life. They may be dealing with other traumas in their life. And so we just want to be compassionate. Also, some of our legal aid clients may not understand as well as some of your other clients. They may not have the level of sophistication or education that your paying clients have. And that could be stress, and it can also be education. But the stress is actually a big factor. Like, people don't concentrate as well when they're stressed out. And this may not, it may not seem like maybe the probate should be stressing them out, but it doesn't mean they don't have other things in their life that aren't stressing them out. So sometimes it's a good idea to ask your clients to repeat or summarize what you've told them, um, to see if they can, repeat it in a way that, that sounds like they understand. We also want to set realistic expectations. I'll talk a little bit more about this later. In probate, that's like in an eviction, like, and if I think someone's not going to win an eviction, I will tell them so they can plan, because some people think that if they have an attorney, things are going to go their way. And I think we all know that's not true. In probate, it's a little different, and we'll talk a little bit about what some of the expectations are. And like I said, one of the things that I like to help people with, the new homeowners, are just making them understand, or helping them to understand, what some of the responsibilities of home ownership entail. So when I use the word probate, I use it very, very broadly. If there's a will in court, you can probate a will or probate the will's immune of title. If there's no will or it's been more than 4 years, you can get an application for letters of administration and determination of heirship. You can do the determination of heirship without the application for letters of administration. You can do a small estate affidavit. Adverse possession by co-tenant heirs is a new option. I think that was enacted in 2017. Or you can also get an order of no administration. We haven't done a CLE on that. Just understand that there are, options. Outside of court, you can do an affidavit of heirship. You can, I say collect, by that I mean, like, if an account is payable on death, like a bank account, you can just go to the court and collect the money from the bank if you have a death certificate and you're the beneficiary of the payable on death account. You can do an affidavit of death. That's for getting property transferred from a TODD, a transfer on death deed. Or you can also do nothing, and that's actually what we occasionally recommend, not often. Most of the time when people come to us when there's real property, they are coming to us, and on their application they'll write that they want the name, they want the deed change, they want their name on the deed, they need to transfer the deed, or they want to get the mortgage in their name. So going into realistic expectations, we can't always get a deed changed. If you are doing an administration and getting letters testamentary or an letters testamentary or letters of administration, then that person, it creates an administration, and they can actually, and you should help them with this if they need it, draft a deed from the estate to the beneficiary. And then the deed is actually in their name. If you're not doing something where there's an administration, there is no authority to draft a deed from the estate to someone else. And so we can't just put the deed in their name. If they're doing something like a small estate affidavit, an affidavit of heirship, a muniment of title, what we do is we record those documents in the real property record so it shows evidence of ownership, but it doesn't get the deed in their name. And that just takes some explaining sometimes. The other thing is, if there's still a mortgage on a property, we can never, ever, ever force the mortgage company to change out the name of the person who died to the client's name. And that's because it's an independent contract between the lender and the borrower. And you don't get to just switch out borrowers because they may not be creditworthy. There can be a whole host of reasons. People may be eligible to get the mortgage in their name once they show like a right to ownership, but we can never get the mortgage in their name, ever. And so I just want to make that clear. And so that's part of what I'm talking about with managing expectations. If they're saying they want that, we should let them know that we can't do that. They have normally, if they've come through me, they have already been told that, and they should have been told it already. But sometimes, and I'm going to say I'm like this sometimes too. Sometimes I ask different people to see if I get a different answer. And yeah. It sounds a little childish, but I'll still admit that every now and then I do it. I'm also just going to point out that if there's a reverse mortgage, we're generally not going to take it because reverse mortgages, their entire business operation is that they're waiting for someone to die so they can foreclose or accelerate the loan and foreclose on the property. That is literally their business model. They do not refinance reverse mortgages. You either pay the accelerated loan or you lose it. And a lot of people are sometimes is very heartbroken when we say that there's nothing we can do with the reverse mortgage and they're going to lose their home. And basically what we give them is a timeline of how long they have to save up the money before there's a foreclosure and an eventual eviction. So one of the things that I like to look at also when someone comes in is whether or not more probate work is needed. And the most common scenario for that is that someone comes in and requests to probate mom's will, because mom died and they're still living in the house and they were taking care of mom. They live in the house and mom left the house to them in the will. And we look at the title of the property and we see that mom and dad bought it together when they were married, and dad's estate was never probated. And so if I see that, I'm going to ask the volunteer attorney to probate mom's will and do an affidavit of heirship for dad. And every now and then we see multiple ones that are needed. They tell us that the one person died, but really a number of people have died, and we need multiple affidavits of heirship. We try to recognize this and ask you to do that from the get-go. But if you are looking at the case and you realize that more work is needed, and almost always it's an affidavit of heirship, not every time, but almost always it's an affidavit of heirship, please go ahead and draft that extra affidavit of heirship and get help the client file it in the real property records, so that if they ever are applying for assistance or something else where they need to show clear title, in case anyone's actually doing a good search, and I'm not saying that the city always does, I hope there's no one from the city here, but we just want them to have good title. We really do. Or if they decide they need to sell it for some reason, maybe their daughter had a grandchild in Florida and they're going to go live down there and take care of the baby and they need to sell the house here. We want them, once they left us, to be able to move on with their life as needed, whatever that is. So that's that. The other thing is a lot of our clients this will be the first time of them like owning a home. And so if you have probated a will or done an application for letters of administration, you do need to draft a special warranty deed from the estate to the heir or heirs. And that it needs to be done, because if there are letters issued so that someone has the authority to act on behalf of the state, like transferring property, that needs to be done. Otherwise, it's kind of sitting out there in limbo land. That home is still owned by the estate of the decedent, and it needs to be transferred to the new owners. We want to tell the clients how to record the deeds. Drafting it isn't necessarily enough. They need to be recorded in order to be effective. So you can either do that for the client or send the client to the real property records to record the deed. When I'm deciding how to do that, it mostly has to do with how comfortable the client is being downtown, because I do it all at 201 Caroline at the real property records that's close to the office. Some people are terrified of being downtown. In that case, they can give HVL a money order. We put it in our Royalta account, I pay for it and I get reimbursed. We can do the same for you, or you can follow that. Or if it's someone that's good downtown and they're like, yeah, I can go to that office, I'm not intimidated by downtown, then you can send them to go record the deed themselves. Tell them how much money and how to make the payment. I can't remember if they take personal checks, but they'll always take cash, money orders, cashier's checks, but then they need to know exactly how much it's going to be. You can check the county clerk's website for that. Generally speaking, as of right now, I think it's $18 for the first page and $4 for each subsequent page. Another thing that we can do is sometimes I've had a client once, and we did an affidavit of heirship for mom and dad who had both died 15 or 20 years ago. He had 5 brothers and sisters. They all had their own homes. He was the one living in mom and dad's house, and they were all interested in transferring their interest to him. While we can't draft a deed from mom and dad to the heirs, we can draft a deed from the heirs to someone they want to deed their interest to.
The affidavit of heirship is proof of all the heirs' ownership that's recorded in the real property records. But we can also draft deeds if other heirs or siblings are interested in this to the person who is our client. And not everyone falls into that situation, but if they have told you that their sisters or brothers or co-heirs are interested in transferring their interest to them, we go ahead and draft those deeds so they can transfer their interest to the client. Yeah, and like that doesn't matter what the procedure was, we can still help with that. If you have probated a will as a immune of title, done a small estate affidavit, or executed an affidavit of heirship, make sure that it gets recorded in the real property records. As much as possible, I like to know that someone is leaving my office and going straight to the real property records, or I want to do it for them. Because people put things off. I think I mentioned that before, that sometimes there's an element of procrastination that may not always understand, but I like to see that it's getting recorded in the real property records, and then I think it's done when it's recorded. The clients are responsible for the filing fees, and filing fees are not waived by a statement of inability to afford payment of court cost or an appeal bond. And I see that we have our first question. Oh, I'm fine with a distribution deed. Sorry. Yes, you can do either one, and I think probably just I'm actually going to go with what Angela said. I would do a distribution deed. I think that's what's in the probate manual. And I apologize. I haven't had a situation where I have needed to do that yet. And I know that sounds funny. I have read the probate code and the probate manual multiple times. I've done the other deeds from heirs to co-heirs. So let's do, it is a distribution deed. So thank you, Angela. And there are forms available in the materials that we provide to you, and I will be showing you some of those at the very end of the presentation. Okay, but filing fees are not waived, and the client is responsible for them. If a volunteer attorney ever wants to pay for that on behalf of the client, you are welcome to, but we do not expect it or ask of you. And like I said, they can either give it to you and you can put it in your IOLTA account, or it can go through us and we can issue the check to you. For new homeowners, we also want to make sure that they're getting their homestead exemptions. Recording the affidavit of heirship, it doesn't always get updated with HCAD. And HCAD, for anyone who may not know, is the Harris County Appraisal District. They are the organization of the county that appraises the values of homes. And they also are the ones who say whether or not you're entitled to exemptions. The most common one, of course, is the homestead exemption. Some disabled veterans will get the veterans disability exemption, and the more common ones among our clients are also the over 65 and the disabled, and that would be for anyone who's receiving SSI or SSDI, and as has been determined disabled by the Social Security Administration. The because they're new homeowners, most of them don't know what HCAD is, or maybe they have some idea, but they don't really understand what they do. And so I will help people actually fill out the forms, and I will either submit it mail it in for them, or tell them to go drop it off at the office. I do see another question. It's in the question and answer. I don't think that's open to everyone, so I'm just going to stop and take it. It says, for an intestate decedent whose only titled asset is a vehicle and all other assets are valued well below $75,000, is an affidavit of heirship possible, or do you have to do a small estate affidavit because of the titled vehicle? You don't. That's going to be the affidavit of heirship at the DMV, and we will get to that in a few slides. So just one second. Okay. So with HCAD, you can send in a copy of the recorded affidavit of heirship, and they will update the ownership to the heirs. And even if it's the type of situation where there's 5 heirs and only one person is living there, if that one person is still over 65 or disabled, they can still get that disability. There was a change made to the rules, oh my gosh, in 2019 about how they are counting that. It used to be that if you
if it was divided, let's say there were 5 siblings total, and our client is the disabled client living in the home, that the homestead exemption and the disability exemption would only be 20%. You'd only get 20% of the exemption to reduce the property taxes. They've changed it so that if the other heirs agree that this person is living there, even though they retain an ownership interest in the home, they'll still give the person living there as their homestead, 100% of the homestead exemption or the over 65 exemption. And that's a recent rule change. But I like to get that on file because I don't want them to run into situations later on where one, the taxes are too high because they're not getting credit for the homestead exemption, or that for some of our clients, they honestly cannot afford to pay the property taxes, which is a shame. But if they are over 65 or disabled, the taxes can be abated and they won't foreclose, and it prevents a person from being homeless. So these are the forms that I commonly fill out. There is the link to the HCAD site. A lot of these can be submitted online now. Some of them do require an affidavit. And so because we have a lot of notaries in our office, I offer that for people. And like I said, I'll often just mail it to HCAD as well for them. If there is not a deed, if you're not doing like showing HCAD, evidence of a deed, then you will have to have a utility bill in the client's name to have the account updated in HCAD. And that might sound obvious to us, well, like that's easy. I've had clients living in mom's house and mom died 5 years ago, and they just kept paying the utility bill in mom's name. They never ever changed it. And so sometimes they just have to be like, and if you want to update this with HCAD and you need to update it with HCAD to get that homestead exemption, you need to get the utility bill moved over to your name, and just things like that. Okay, this is just a slide that shows what HCAD actually requires to do that. I'm not going to read it to you. It is available on their website and on the forms. Also, sometimes people don't realize they have to even pay property taxes, and that's most often the case when they're living in a house that was owned by grandma. Grandma died in her 90s. A lot of the homes most of our clients' homes tend to be lower value homes, and grandma may not have had a tax liability ever, because if the home is low value enough, when you turn 65, the school taxes get capped. And no matter what the value of the home is, you're never going to pay more than what the home is worth when you turn 65. And the school taxes are the highest percentage of any property tax bill. And so maybe the home is low value. Like I said, grandma lived there 30 years, and maybe and it's possible some of the clients come in and they're inheriting homes that don't have a tax liability. Those are honestly the low value homes. But grandma never paid it. When that home is transferred from grandma to someone else, the appraised value jumps up. It actually, you get taxed on the value of the home when it's transferred to that person. And so, whereas grandma might not have had a tax liability, the new client might have a tax liability. And they're like, well, grandma said, she never paid it. And so I don't have to pay it because this house doesn't have taxes. It's not the house that doesn't have taxes. Grandma didn't have taxes. And so I just like to show them, make them aware of that, make them aware when it comes in, they need to pay it. Because I don't want them to lose the home if they're not over 65 or disabled and not eligible for an abatement. Also, sometimes they may not realize it because grandma was doing an abatement and the taxes are still owed. And as long as they're eligible for that abatement as well, they don't have to pay the taxes, and they can prevent foreclosure if they have those exemptions. And so I like to make them, I want to make sure they're getting the exemptions they're entitled to, or make them aware of what they need to do in order to keep the home and not have it be foreclosed on by the taxing authority. If there's a mortgage, if they're not able to refinance in their own name, if they keep paying the mortgage company doesn't care. They will take money from anyone. They will only talk to the new owner if you have letters and you have and you can show the authority that you have the authority to talk on behalf of the estate. But if you're doing a small estate affidavit or an affidavit of heirship, the mortgage company won't talk to the client about the mortgage. They just have to keep paying the bill. And quite honestly, that sucks. But for some people, that's fine. Whenever the lien is released by the mortgage company, if they have that small estate affidavit or affidavit of heirship on file in the real property records, it's their property upon the release of that lien. They also need to pay the property owner association fees. That can be a condo association or a homeowners association. Most people know if they have to pay the condo fees. HOA fees trip people up though sometimes. It seems like a small amount, some random organization they never heard about, and they don't realize they can foreclose on them. So if they're in a HOA, I want to say you need to continue to pay the HOA fees so this home doesn't get foreclosed on. Also, like if there's not a mortgage, and there's not an escrow with homeowners insurance or the property taxes, then I like to remind them that they should maintain homeowners insurance. Some of the homes that people inherit are not insurable because deferred maintenance is actually a FEMA term, but I kind of like it because the house hasn't been maintained and is uninsurable. So I don't beat people up on things like that. I just make people aware that if something happens, this is something that will protect them if if the home is insurable, and I hope that everyone can afford it. If they're doing a mortgage, it should be part of the escrow. Um, so the other thing, and you don't necessarily have to do this as part of your case, but maybe you can contact us and say, hey, I just probated the estate for this client, and I'd like to help them protect it for the next generation. There's two common mechanisms for that, and that's the will and a TODD, a transfer on death deed. I assume that everyone knows what a will is, and I'm not going to go into that. The transfer on death deed is new-ish to Texas. I can't remember if it was 2015 or 2017 when our legislature codified it for us. Over half the states have a TODD. Previously, Texas attorneys would draft ladybird deeds for people, but we have the transfer on death deed now, and we should be using it when applicable. So I prefer TODDS for most of my clients over a will for several reasons. Wills have to be probated, and not everyone knows that a will has to be probated. Sometimes people bring us wills that are 10 years old, and they're getting around to it because a title issue came up. They always thought it was theirs, and they didn't realize there was a time limit. And it's possible that our clients' heirs may not know either. With wills are better, though, for people who have complicated they have if the way they would like to leave the property is somewhat complicated, a will might be better equipped to handle that. Wills can also be revoked by executing a new will or destroying the old one. Transfer on death deeds have to be filed in the real property records, and they have to be filed before the person's death. Some people will just put the transfer on death deed in a drawer and never file it, and that doesn't do your heirs any good. There's a question. They didn't. Oh, they did. So Brian asked if they removed the TODD form from the statute. When they drafted it in or whenever they first introduced the legislation in 2015, they had a statutory form, and then in 2017 they amended it, and then I think in 2019 they took it out altogether. Yes, Brian, you were right. You can go back and use that form. It had to do. There was confusion over how to use the anti-lapse provisions and things like that. You can draft it however you want, and you can even take that old form and take what you want and throw out the rest or put in whatever you want regarding the descent or how it's going to be distributed and alternate beneficiaries, and if it goes to heirs of the first beneficiary before it goes to the alternate beneficiary. It was just hard to put that in a statutory form, so they did take it out, but you can still use it as a template if you like. So there is no statutory form anymore. A transfer on death deed will always trump a will, meaning that no matter what is in the will, if there's a transfer on death deed on file in the real property records, that's the way the property is being distributed. The transfer on death deeds are revocable, but you have to file the revocation in the real property records. If you have a flip-floppy client, maybe a transfer on death deed isn't the best because they changed their mind. We have some people that apply to do a new will every year because one heir has fallen out of favor and a new one's fallen into favor. For those people, transfer on death deeds aren't ideal. And then they also have to pay that filing fee every time. And then, like I said, it's not as ideal for the complicated, when they say if this person, then this, and if that, then this, it still can be done in a transfer on death deed, but it's easier if you're I have one to my spouse and then to my mother. And it's easy. So, and yes, and I've done it for myself too. So, the other thing that that I like to tell people, especially if they've gone through the process of trying to get it from other people, like the assets from, a decedent, is to have them check with their bank to see if their bank account is payable on death. Then you don't have to do a small estate affidavit or anything like that. So, or if they have any financial account, make sure it's payable on death. If they have a life insurance policy, make sure they have their beneficiaries listed. This happens more common than the number of people that don't have beneficiaries listed kind of surprises me sometimes. And I think it's because they have to give social security numbers when they're naming the beneficiaries. And if they don't have that handy, they think they'll get to it later, and maybe they never get to it later. If you don't have a beneficiary listed, then then it doesn't pass to your beneficiary. So you can always remind people to do that. And they also tell people don't get a reverse mortgage. Reverse mortgages are the devil. Don't do it. There's like one person out of 1,000 that I think it's actually a good deal for, and the other 999 is an awful deal for. Um, the other thing is some people are going to be inheriting dilapidated homes or homes that are in really, really poor condition, that deferred maintenance that I talked about before. And so there are some programs around town. Rebuild Houston, the City of Houston Home Repair are places where people can apply to have their homes repaired or rebuilt. Baker Ripley also has a disaster recovery, and some people would benefit greatly from this. I've had some people that have homes with no insulation. You can't cool a home with no insulation and have an affordable utility bill. Things like that, like people do need assistance. Um, Another reason, just to let you know, some people do come to us because of the property tax foreclosure. Normally, we will ask you to take all of that together. If a person is eligible for an abatement, we will ask you to do what's necessary to get the title in their name, and that's almost always an affidavit of heirship, and to represent them in the property tax foreclosure. I already have pleadings drafted for that. Basically, you just have to prove to the court that you've put it in your name, you qualify for an exemption or the abatement, and the other side dismisses the case. And that's mostly Linebarger or Brandon Purdue. I can't remember the name. They represent most of the taxing authorities in this area, the school districts and Harris County and HISD. So that's actually a pretty easy process to prevent foreclosure for someone and help keep someone homed. Unclaimed property is a reason that some people come to us, or sometimes people are not in a position to get the help that might be, maybe they're in conflict with the other co-heirs and we can't help them the way that would be most helpful or that will allow them to actually get property, like in a bank account, like financial institutions. Um, and we don't take contested cases, generally speaking. And so maybe we might help them with an affidavit of heirship and tell them to check the unclaimed property site, and hopefully they can actually get whenever that financial institution turns over the money to the Secretary of State, then they can use it to get it at that time. People don't like being told that they're going to have to wait years to get it, but sometimes it's that or nothing. Just so y'all know, for the unclaimed property for property owned by an estate, if it's between $0 and $5,000, you can use an affidavit of heirship. 5 to 10,000, an affidavit of heirship that's been filed in the real property records. 10,000 to 50,000, a small estate affidavit, and 50,000 or more, you need a determination of heirship. So to answer the question about the vehicle, the Department of Motor Vehicles has a form that you can use to transfer title from the decedent to the heirs. This only works if there's not a lien, like the title is actually released to the decedent. Otherwise, the lender still has title and it won't work. If you keep paying that bill, whenever they do release the lien with the DMV, then you can use this affidavit of heirship form. Um, IRS issues. I'm going to apologize. I didn't write these slides, and I hope the person who did write them doesn't kill me. We do have a low-income taxpayer clinic at HVL, and I asked her to help with just a few IRS issues that people might have, like after someone dies. Um, People can file the decedent's last tax return. They only have to do that if the decedent had an individual filing requirement. You can check the IRS publication 501 for the filing requirements. The final tax return covers January 1st to the date of the death. The final income tax return is due at the same time the return would normally have been due. So, April 15th for most of us. Or I guess if they lived in Texas this year, it would have been later because it was extended. The personal representative can file it. That's an executor who's named in the will and appointed by the probate court. You actually have to have the letters. The administrator appointed by the probate court, again, you have to have the letters, or anyone who is in charge of the decedent's property. I don't understand that requirement. If y'all start asking questions now, I'm going to refer y'all to our low-income taxpayer clinic attorney. So please, no questions. Who should file the last return? The executor or the administrator can, if needed. Keep in mind that it's like if we're doing an affidavit of heirship, that's normally because someone died 10, 20 years ago. We're not looking at filing a tax return. This is more for our independent administrations or our probating the will. That's mostly when we're looking at this. And the only reason that most people are even interested in filing a return, quite frankly, is just if the decedent was owed a refund, then maybe the heir wants that refund. Just so y'all know. The surviving spouse can file a tax return without probating or getting letters of administration. If they've always filed a joint return, they can file the joint return as well. That does create joint and several liability if there's an issue with that, though. The person in charge of the decedent's property. Oh, I'm sorry, there is a slide for this. They file Form 1310 and indicate that they will pay out the refund according to the laws of the decedent's state of residence. You have to provide a copy of the death certificate or proof of death. Just so you know, VITA is most of our Baker Ripley. That's the Volunteer Income Tax Assistance Program. And they help people file their tax returns for free. In order to qualify for the VITA services, you do have to be low income. Any one of our clients, if there's an HVL client, they're going to qualify for VITA. They will assist, but only if you have the letters of administration or letters testamentary or that joint return. I understand. Otherwise, they're going to have to go to a paid tax return preparer or a CPA. Once an executor or administrator has been appointed, a tax practitioner can work with the representative of the estate to resolve remaining tax issues such as tax debt. To be honest, this is rare for HVL clients. And that might be the type of thing where we're doing things later on. Someone has raised your hand. I have to unmute you to talk. If you don't mind holding your question or typing it, I will unmute you at the end, okay? Thank you. Okay, and we are almost at the end, just so you know. So I think I've mentioned this before. We have a medical legal partnership, and our medical legal partnership attorney, Stephanie Summerlatte, has also asked me to ask all of y'all to consider taking a guardianship case. Guardianship cases are also done in the probate courts. And probate courts are very friendly. If you haven't been to any of the series that we've been doing this month, I think you've heard everyone say that they're very friendly. Just one second. I see y'all are asking questions now about the tax things. I almost left them out because I don't know that I'm qualified to answer the tax questions, but I will to the best of my ability. And I'll get to that in just a second. So with guardianship, they are rewarding cases because you're helping a parent be able to care for their adult disabled children. They are always uncontested. We do not take contested guardianships. They're in the friendly courts. The probate court staff are wonderful, wonderful people. They are friendly and they help us. HVL will provide templates and mentorship throughout the process. And if in order to to take a guardianship case, to represent that parent in a guardianship case, you do have to have a special CLE. That CLE costs about $200 and it's 4 hours long. We offer that for free to people who take guardianship cases. So if this is part of your regular practice and you're coming up, your certificate has expired, consider taking a guardianship case and getting that for free. Okay, I'm also reminding y'all to take cases. I am going to answer your questions in just a second, just so y'all know. And I wanted to show you some other things too. You can contact our pro bono coordinators. We have, just so you know, for any probate matter, we have the probate manual and text docs, and I was about to show y'all that. And you can log on to the portal at hvl.legalserver.org. This is our CLE information, and I'm going to actually go to the questions. So liability. If a personal representative did not file a return on time, if there is a filing requirement and the estate owes money, then it's my understanding that the representative does have that duty to file that. But I don't want to, I'm not, that is my understanding. And I'm going to say that I might put you in touch with our LITC, LITC attorney, our low income taxpayer clinic attorney, or ask if anyone else in this CLE knows the answer to that question. I recognize some of the names here. I know we have a bunch of smart people. And if anyone knows the answer to Brian's question, oh, that was written only to me. I apologize. So someone did ask if there's liability if a personal representative did not file a tax return on time. I think that if you are appointed the representative, you are supposed to take care of the decedent's affairs. And if the decedent was going to owe money, I think that has to be taken care of because the debts have to be paid. Okay, someone else is asking, is a ladybird deed and the TOD the same thing? No, they're different. A ladybird deed was our workaround when we did not have the TOD. I can't tell you exactly what the difference is off the top of my head. I would have to look it up. But if you have a choice, use the transfer on death deed. It's codified now. We didn't have it before. Like you could, if you filed it, it didn't have any effect because it wasn't codified, but it is now. So if you have that, use a TOD now. Okay, I apologize. To the person who raised your hand, if you'll raise it again, I can unmute you. I am looking for the person whose hand was raised. I don't see your hand.
It looks like it's Amanda Taylor.
Okay, Amanda, let me just. Okay, you're allowed to talk, Amanda.
I apologize. I'm driving and I may have hit a button accidentally.
Okay, then I'm going to mute you if that's okay. And then I'm just going to show y'all a few more things. So I think that y'all can still see my screen. So this is TextDocs. It's a lot like ProDocs. If you're familiar with that, it was actually created by the same guy who started ProDocs. And I'm just showing y'all the application for the probate of a will, just so you can see what kind of forms that we have available for y'all if you decide to take a case. So like I'm on it right now, and I've just set this up for test/test person. And so it asks for information. So let's do it for Harris County. It asks for a court number. Honestly, we don't know the court number at this time, so I just put X. It's a statutory probate court here in Harris County. The docket number, I don't have that yet. The name of the decedent. We're going to say test decedent. And then we go to the next page. We want to know the decedent's social security number. The last 3 digits are 789. The driver's license number 123. The state where it's issued, Texas. And this is basically prompting you for all the information that's required for the application to probate a will. The residence, let's go ahead and put our HVL address. Why can I not? Bagby, Houston. Next. We're going to say why this court has jurisdiction to be here. So we'll say reside in Harris County, was domiciled here, but you can pick whichever one is the correct one. I'm not going to spend, I just want to show y'all the way it prompts you and what it gives you at the end, so you see what kind of forms we have available for y'all to use. Medicaid benefits, this is so we know that if they need a MERP cert, I'll go ahead and put that they did, and I'll put that there were no benefits applicable. And we'll go to the next page, but you would just fill it in like date of the decedent's will. Let's make it the beginning of this year. Date of death, let's say, okay, age at date of death. I'm making things up just so y'all know. I'm going to say that not more than 4 years have passed because I want this application to go through. The names of the applicant, I'll go ahead and put my name. Whoops, I can spell my name right. I'm an individual. This would be like for your client. If I was your client, the last 3 digits of my social, let's do 456. of my driver's license. We'll say the same thing. And we'll say that I also live at Bagby. The executor, I'm also the name of the executor because I'm normally the executor and the applicant are going to be the same people. And I don't know if you can see over here, it shows that it's going down, like how much more we have to go before it can pop out this application of probate or will. So we're going to say there's real and personal property. The subscribing witnesses, I'm going to say it was Jane Doe and John Doe. They were the ones who witnessed the will. Were there any children born after? I'm going to say that there weren't. Most times there weren't. Occasionally, if that's the case, then of course you would fill this in. If we're going to say that we're never divorced. Okay. Required information. I don't have to put anything in here. This is if like you clicked a button on another page that required an explanation later on, but I didn't have that here. So we're going to go to the next page. The primary attorney. I'm going to say that the primary attorney is one of my coworkers who is watching today. She's going to be my attorney. And I'll put her state bar number in and her phone number. And we'll just do this. And so this is going to be her signature block. And we finished. And so now it's making the document for us. Let me download it. And then I will open it and show it to y'all. Oh, I apologize, guys. I made these polls to ask y'all, and I'm actually, Kiara, do you mind actually like launching the polls while I'm going over this? I'm just kind of curious who all's
Sure.
watching. Thank you, Kiara. So just so you know, this is what it made for us. It shows it's, okay, gonna move this poll away. I'm just curious who all here has a will. And this is anonymous, just so you know, all the answers are anonymous for this, and I have a survey for the very end. It looks like we're actually going to finish up a little early. I don't see many questions, but I do appreciate the people who did ask questions. Oh, sorry, there's another question here. Oh no, I already answered that one, sorry. So this is the, move this over just a tad. So this is the document that you're given. I don't know why, if you see something that's not filled in, it means I probably missed a question when I was doing the actual form itself. I think this should say applicant Lisa Everett. That should say individual, I believe, but I would just check. You can check, but it's pretty much made the entire. Okay, it didn't ask for some of the questions. So this one, decedent owned real and personal property described generally as, I might say like a house and a bank account having an aggregate probable value of $50,000. So some of this will be fill in the blank later on. That says whether or not I need to do that MERP cert, the Medicaid benefits. It has, you know, the date of the will. I think that this is supposed to be USA. I think I would have to check the actual code. Whenever there's any blanks, I check the code because the probate quote is actually super, super helpful, just so y'all know. Yes, there's a question about whether or not y'all are able to access the recorded seminars in the series. Yes, you are. If you signed up after every one, it's my understanding that you get an email from Ellie in our pro bono department, and she is sending y'all a link to the recorded video, and y'all can watch any of the 3 that we've recorded before. Why are reverse mortgages not a good idea? Reverse mortgages are not a good idea if you, because you lose, reverse mortgages cannot be passed on to the next generation. So if you don't have any generation, then that's one thing. Also, they can foreclose on owners of reverse mortgages if they fall behind on anything like paying property taxes, not insuring the home, or doing other things. Reverse mortgages, generally speaking, are predatory. You know, I was talking with one of my cohorts at Lone Star Legal Aid, and she said that she had one client ever that she actually said, like, I think it's okay if you get a reverse mortgage, and it was someone who was terminally ill, had no heirs, and wanted to do a little bit of traveling before her death. And that was her way of getting money fast from the, the equity that she had in her home. And it was like a for sure terminal illness, and she wasn't going to need to live in it later on. So most of y'all have wills. That's kind of exciting. So good for y'all. Those of y'all that don't have wills, consider making a will. I know we didn't provide information on how to make a will, but I would like to encourage everyone to do that, or to make your accounts payable on death. It will make things so much easier for your heirs. So I don't know if I answered your question about why I think reverse mortgages are bad. They're predatory. People don't realize that they're not going to leave their estate to the next person. They don't realize that if they make a mistake, like if they fall behind on their homeowner's insurance, that's one of the ways that the loan can be accelerated, and then you have to like repay the entire loan, or they can foreclose on you. They're just generally very predatory. So this is the actual like will. I just wanted to show y'all. This is going to sound ridiculous. I'm going to check the code. I didn't realize the applicant had to sign, but definitely Bobby, my attorney, has to sign. I also just wanted to show y'all, whoops, sorry guys, that I was going to show y'all, sorry, I thought I was more prepared. I thought I already had this pulled up. Give me just 1 second. I'm going to stop sharing my screen for just 1 second so I don't show y'all things I'm not supposed to be showing you. But I did also want to show you the probate manual and the way the forms look in the probate manual. Okay, I'm going to come back and share my screen. Okay, so just so y'all know, I'm back over here. This is like when you get access to HVL, we'll give you access to the probate manual. The probate manual forms, honestly, it's not the easiest way to find things. They just have numbers. If you take one of our cases though, I will tell you which forms I think you need. This is form 5. This is application for probate of a will and issuance of letters testamentary. And this is more fill in the blank. Instead of filling it in through a program, you fill it in here. It doesn't have a caption. You have to add your own. And then it says where to fill everything in. If it's referring to numbers, it's because they have a worksheet that comes with this, and you fill it in beforehand. And if you have a 24-5A, you fill that in, or 25-4B. So this might be, I'm not going to say what they are because I don't have the form pulled up, but basically anywhere where there's something in bold and in brackets, it means that you're supposed to fill it in and insert the information. You can remove the brackets for the actual like submission of the document. Another thing that I just want to point out, whenever there are multiple paragraphs like 1, 1, 1, 1, it means that you are supposed to pick the one that is right and delete the others. It doesn't mean you have 4 paragraph 1s, and that's how you know when you have to choose something. Here, there's only 1 paragraph 2, so you use this one. 3, 4, 5. Here, the names of the subscribing witnesses are, or the will was wholly in the handwriting. So this is when you have a formal will versus a holographic will. And I just wanted to point out how to do that.
Yeah, Lisa, I'm not sure if you, it doesn't look like you're sharing your screen. I'm not sure if you were intending to do that during this portion.
Oh, I apologize.
Okay.
Okay, guys, sorry. That would be super confusing. I apologize for not actually hitting to share my screen. So I just want to point out that this is the form. If you're using the probate manual, these are the forms that come from the probate manual. And thanks for pointing that out, Kira. I can see my screen. How come y'all? So when there are numbers like this where it says C245A or 25B, there is a worksheet that comes with this, and you basically fill it out, and you would fill it in based on like what you have filled in there. And that might be whether or not you're doing the name of an individual or an entity. And I'm not going to, like I said, I'm not going to say what it is, but I'm just going to point out that it comes with accompanying worksheets that you can use. Someone is asking, do any HVL clients have their wills probated in Montgomery County? We do help veterans, and for veterans, we do help in all the surrounding counties as well. We will still mentor you, but we may not have experience in the Montgomery County courts. If you're coming up against an issue, though, we will reach out to our volunteers or to that we know might practice in that, and maybe ask if they can answer your questions if you have something particular to Montgomery County. But the form should be the same no matter what. So I didn't see what y'all's practice areas were, but I will look at it later on. But I just also want to point out that if you're using one of these forms, when it says something like 1, 1, 1, and 1, that means that you're only supposed to have one paragraph 1. So you pick the one that is appropriate for your situation and you delete the others. You don't leave them in. The other thing I just want to point out, if you're using a form and you're not used to using forms, whenever it's like bold and in brackets, you're supposed to actually like put something in. Whoops, I'm not editing. I don't want to edit the actual form, but so I would download this, save it as, the application of probate. And I would actually like put in the name. Like, so if it's me, Lisa Everett is an individual interest in this estate. And then I would fill in the information and I would delete the other ones. When there's only one number, of course, you have to use that paragraph. 6 here says the names of the subscribing witnesses. So this is for a formal will. And number 6, the will was wholly in the handwriting of the decedent. This is for a holographic will. So you just pick what is appropriate if you're using one of the forms from the probate manual. And I think y'all saw the text docs and the way that came out. Okay, so there y'all are answering, do you feel like you could take a probate case after attending the probate CLEs this past month? There's a few of y'all that are saying no. I have a survey at the end that y'all are gonna, I don't know if you have to launch it also, Kiara, if you don't mind launching it. I would appreciate if you could say why or what more you think that you need. I'm just curious. This series was intended to be something to help set y'all up so that you would feel comfortable taking a probate case, even if you hadn't before. And if you don't feel comfortable, I am curious why. It is completely anonymous. I will not know who submitted what, but I do appreciate y'all's feedback. I want to thank everyone who's been coming week after week. Y'all have been a great bunch and I appreciate the questions. Okay,
And
so
Lisa, I don't see an option to launch a survey. That might only be on your end, unless it's
okay.
automatically done.
I think it might be automatic when I end this, just so y'all know, guys. I think it might come up automatically at the end. I hope so. I apologize. It's my first time doing a survey. And if not, I'm going to go ahead. I'm going to stop sharing my screen again. Just one second. Okay, and I will put in the
And we've
chat.
got one more question in the chat, Lisa. Oh no, one more question, sorry, in the Q&A box. Do we have to put a Medicaid paragraph in Texas estate code?
So I think that if the estate is worth more than $10,000, you actually do have to say whether or not the decedent received Medicaid benefits. And even though it's like 100% required for amendment of title, I'm seeing it prompted in a lot of things too, including the small estate affidavit. And so getting a MERP cert is super, super, super easy. It's a form that you just send in to the Texas Department of Health and Human Services. They send it back pretty quickly. And it just says whether or not they want a claim against the estate. If they don't, then there's nothing to worry about. If they do, chances are our client qualifies for an exemption. That's for adult children living in the home. I can't remember. There's other exemptions too, but our clients generally qualify for them, even if there is, even if Medicaid does want to make a claim against the estate, they will almost always waive it for our clients, just so y'all know. I hope that answered your question. So I apologize. I was going to put my email address in the chat. So let me get back to that. And if anyone would like to send any, and it of course wouldn't be anonymous, but if you want to say why you don't, why you don't feel like you could take a probate case, I'm just curious. I would like to be able to help y'all as much as possible and make people feel comfortable like you could do it. I just do want to emphasize again that our probate courts in Harris County, I can't speak to Montgomery County because I've never been there, are super friendly. And something I've heard from all of our volunteer presenters the past 3 weeks is that if you submit things in advance, the court staff will review it and then give you a call or email beforehand if they see an issue. And so I've never seen, I don't want to discourage people from taking a family law case or anything, but I don't see that in the family law courts. That's very unique to the probate courts. And also because most of our cases are, I'm not going to say everyone loves each other, but we're not taking contested cases. You're not dealing with that antagonism. And so that helps as well. And if I don't see any more questions, I managed to take up a whole hour. So I was a little concerned as to whether I could, but I just want to go over some of the other issues that our clients especially might be facing. And for all you know, it might be in your private practice as well. Not everyone knows everything. Like, we don't learn about HCAD. If you don't have a home, why would you know what HCAD is? And so, or if you've never been responsible for that, or you've never had to protest the property taxes, maybe you don't understand that. And so it's just like, just talking to people about what's coming up next. And so that's something I hope that everyone will do with their HVL clients as well. Thank you everyone for coming. I'm going to go ahead and end this. I hope that you get the survey. If not, the biggest question I had was like, what would make you feel comfortable taking a case? So thank you. We do not do tax protest. Someone asked if we do tax protest. We do not. But I can tell you what I've heard from people who do. I've heard that if you're trying to protest your taxes, it's a good idea to get an estimate for a home repair that you need to show like how horrible your home is or something like that. Like you need a new roof and it's going to cost this much money. So they need to knock that much money. And you haven't made the repair because you don't have the money or whatever. So they should knock that much money off the appraised value. I've heard that that's one of the things they love the most. I've also heard they don't like attorneys, and I don't know if that's true or not. So I will tell you, in my relationship, my spouse does it, not me. So, anything else? I'm willing to take questions for one more minute. Oh, it's 1 o'clock. I'm going to go ahead and stop the recording, and thank you, everyone. I really do appreciate it when you'll ask questions.